Hello, we're here today talking about the infractions hearing operations. As this audience well knows, the person we're going to be speaking to, Naima Stevenson Starks, the Vice President of Hearing Operations. So, Naima, to that point, obviously you've talked with a lot of these individuals last year at this time. Why don't you give us an intro of what your role is and what your daily responsibility looks like?
Great. Thanks, Cam, and happy to be here to share a little bit about hearing operations and the infractions generally. But it was almost a year ago where this position was named and created, the Vice President for Hearing Operations. We had not had an executive level position within the national office that worked with the adjudicative side of the house for our infractions process. Part of the impetus for the creation of the role was in part due to the recommendations from the Commission on College Basketball that established, in addition to our peer review infractions process, an independent adjudicative process to deal with a certain subset of cases that I know we'll get into a little bit later on. But with the creation of this new system within our infraction structure, I think President Emmer thought it was prudent to name an individual at an executive level that would work with both the peer review structure, our Committee on Infractions across all three divisions, and our infractions appeals committees across all three divisions on that side of the house, and the staff, the incredible staff that support both the Committee on Infractions and the Infractions Appeals Committee, but then also someone to work with this new independent accountability resolution process that we'll get into a little later. So hence my role was created. I went through the process like everyone else of interviewing for that position and was selected for the position again almost a year ago. I think it was around June 3rd of 19 that I think folks were actually in the middle of regional rules last year here in Indy when the announcements were made. So happy to be in the role. Like I mentioned, I have an incredible staff here in Indianapolis that I work with, a staff of 8 that support the Committee on Infractions and that function, and a staff of 3, a newer office. Previously, the infractions appeals committees across all 3 divisions were really supported by folks out of academic and membership affairs who were liaisons to those various bodies. But about 2 years ago now, Donald Remy decided that we needed a dedicated staff to that infractions appeals committee function, similar to what we have with the committees on infractions, and hence hearing operation. Now, both of those offices are reporting up through me. So that is my role.
Excellent. And it's you touch on a very interesting point. What a difference a year makes. Because last
Absolutely.
together and your discussion was taking place in front of a full audience. So shifting gears to COVID-19, can you discuss the impact it has had on the hearing operations?
Yeah, so we've made the leadership of the various committee on infractions, um, committee on infractions, infractions appeals committee, and the independent structure determined that given the environment, it would be prudent for us to not necessarily obviously have in-person hearings that wouldn't be accommodated right now. So we have suspended, or the leadership of the various adjudicative bodies suspended any in-person or arguments on the infractions appeals committee front, or hearings on the COI, or now this new independent structure front through May 31st. And at that point, was going to be an evaluation, and there continues to be an evaluation of whether we can accommodate virtual hearings. On the Committee on Infraction side, many of our expedited hearings have already been in a video conference context. because those are more streamlined, straightforward kind of hearings. So now we're exploring whether or not there's the ability for some subset of cases to have those hearings be conducted, in our new normal of a virtual format. Because even if we get to the point, which we are in several states, of things beginning to resume and open up, you still have to accommodate for travel. You would still have to accommodate for social distancing in any environment that you would be in person. So as a result, we're in earnest trying to figure out and work with the various adjudicative bodies to determine how we could accommodate hearings and oral arguments in a virtual way. But right now, through the end of this month or through the end of May, we would have no in-person hearings, and we're thinking through how we would be able to accommodate virtual hearings going forward for some cases that would lend themselves to it.
Understood. And then in terms of the hearing operations unit, can you provide a brief update on the work of the Committee on Infractions?
Yeah, so for the hearing operation units, so as I mentioned, we have in hearing operations, we have the staff that supports the Office of the Committee on Infractions and supports Committee on Infractions across all 3 divisions. That's a staff of 8. And the work of the Committee on Infractions is still continuing. Obviously, we've still been dropping, the Committee on Infractions has still been dropping decisions, even in this COVID environment. So those are cases that have already been processed and heard in many instances, or were being processed through summary disposition. And many have been that of the decisions that have been dropped recently have been in this negotiated resolution context. And that is one of the other kind of byproducts of the recommendations from the Commission on College Basketball. There was this thought that, yes, we've got this set of cases that might need to be processed through what we'll get to in a bit in the independent accountability resolution process. But similarly, we have cases that probably can be resolved more quickly than our existing structure and the previous structure really allowed for, when the enforcement staff, the institution, and any involved individuals agree not only that conduct occurred that was in violation of NCAA rules, but that the penalties that should be connected to those violations are also agreed upon between the enforcement staff, the institution, and any individuals involved. That's a key distinction between that process and the summary disposition process. In summary disposition cases, there is agreement among the parties that violations occurred, but ultimately the penalties are still determined by the Committee on Infractions. So that's a process that doesn't require a hearing, because it's pretty much most issues are agreed upon, but the Committee on Infractions really is the final say on the penalties. In negotiated resolutions, while those the Committee on Infractions still has to approve any negotiated resolutions, and they essentially release those decisions, the penalties are agreed to between the enforcement staff, the institution, and any involved individual. So that was a recommendation from the Commission that was adopted by the membership, along with the creation of the independent structure. And we've seen over the past year many cases being resolved through that negotiated resolution process, which is a benefit to member institutions because it allows things to happen more quickly. But summary dispositions, negotiated resolutions, and any cases that had been heard prior to COVID really, hitting in earnest, those cases are still being decided by our Committee on Infractions. So that group is still well underway.
And the key word I'm hearing there is efficiency. And
exactly.
in terms of case efficiency, The timing of the resolution of cases is always a topic that raises that comes up related to the infractions process. Any thoughts from your perspective on how the efficiency levels are?
Yeah, so we are in the process of, or it may have already been released by the time this is shown, but we're working on our annual report, the Infractions annual report, which is something that we work with in collaborations with our good friends in communications to put together a report each year that goes through a variety of metrics related to the infractions process. So one of the things that, as you noted rightfully, is always a topic is how quickly cases are resolved. And I do think that the staff that supports the Office of the Committees on Infractions has really helped the committees shepherd those decisions through. We can only really control on the hearing operations side, and from the committee side, once the case gets to them. So that's really from when the notice of allegations is issued through the time in which a case is heard or resolved through summary disposition or negotiated resolution, and then any decision that results after a hearing is had in those contexts where there is a contested hearing. So you'll see that the time period really that is the most in the control of the committee and the staff that supports it is really that time between when the case is heard and when the decision is ultimately released, for consumption by the membership. And that time period has definitely shrunk over time.
And that's great. And a lot of what we've just been discussing is based from the Commission on College Basketball, obviously under the umbrella of Division One. When you look at Division Two and Division Three, understanding that there's a Division Two task force that was created, what are some points that group has been working on as far as you know?
So the task force was created in Division Two to really take a look at some of the issues that were prevalent in Division One that led to some of the changes that we've talked about, including even before the Commission on College Basketball, the last iteration of kind of the enforcement working group, which was a review of the enforcement infractions process at that time. I think it was back in 2012. And as a byproduct of that, we already had a set of changes in Division One that we've been operating under for quite some time now, which includes, instead of just secondary and major violations, which were the two categories of infractions violations previously, that was provided some greater variation with the leveling. So we have now level 1, level 2, and level 3 cases in Division 1. Level 1 being the most significant threats to the collegiate model, and 2 and 3 flowing from that. As a result of that working group, we also have aggravators and mitigators. So you can be in a level and then have aggravating factors that kind of make your case even more significant, and mitigating factors that could mitigate your case down from a certain level. So those changes are already in place, and all of it was really designed in part to have greater transparency on penalties. So in addition, one of the other byproducts of that enforcement working group in Division One was this penalty matrix. And what we find now in a lot of cases, previously it was whether a case was, major or secondary. Now there's a lot of attention being paid to whether a case is a level 1 or level 2, and what there are aggravating and mitigating factors that could apply. And then once penalties are assessed by the Committee on Infractions, whether or not where in that penalty matrix that penalty for a particular institution or an involved individual fell, and whether that was appropriate. And that's why we're seeing a little bit of an uptick in appeals. But the combination of the work between the enforcement working group and some of the recommendations that were the byproduct of the Commission on College Basketball has led Division II to think, well, are some of these things appropriate to be borrowed in Division II? And the question still remains to be seen, but that's what the task force was really designed to get at, whether or not some of these concepts would be appropriately positioned in Division II. So that conversation began last summer of 2019. And I think that there are concepts out for feedback from the membership. I think the Management Council has determined that some of the things that have been implemented in Division I would be appropriate to review and consider adoption, not all, but some in Division II, and those concepts are out now for some feedback.
Understood. And what about Division III? Any trends that you're seeing there?
Division III has not been as active. There was a period of time where many of the cases dealt with the financial aid legislation and the restrictions on providing student athletes, any kind of aid that's not also available to the general student body, which is one of the core tenets of Division III. So there was a period of time where there were quite a few cases kind of in that framework, and that has lessened. I think institutions are situated with familiar enough with how that legislation works in Division III, where we're not seeing the same level of issues in that space. So that division has been relatively quiet. I'm sure that they are happy about that.
Now, back to Division I and specifically the Infractions Appeals Committee.
Yep.
It looks like you're expanding that roster from 5 individuals to 7. So why did the committee decide to expand?
Yeah, so one of the things, that I think is not always fully appreciated, and this goes for division, the Committee on Infractions and the Infractions Appeals Committee, really across all 3 divisions. But as we've talked about, since there is more activity with our Division I institutions, this is particularly pointed for our committees at the Division I level, and that is this is a lot of work for people who are volunteers. Our committee members, which often gets overlooked, are doing this on top of their day jobs, so we've got commissioners and athletic directors and law professors and sitting presidents is now part of the, kind of background that is sought after for both our Committee on Infractions and our Infractions Appeals Committee. And that is just a lead up to answering your question. It has become increasingly difficult schedule-wise, et cetera, for the 5-person Infractions Appeals Committee with conflicts, institutions that they may have been affiliated with in the past, et cetera, and having to have those subset of recusals, that whittles your 5 even smaller, depending on what case is coming before them. So the 7, increasing to 7 was something that the committee thought was particularly important. They are not moving to the panel format. 7 is still manageable. So in the first instance, if all 7 are available, all 7 will hear the case. But at least this now provides some flexibility if you fall below the 7 for a conflict reason or just unavailability, you still have a good core of folks to hear any appeal case. These are important cases, important for the institutions and the individuals asserting their appellate opportunity. So we want to make sure that we've got a good core number of folks that would be able to hear any case that comes through the system.
That makes sense. So will the appeals be heard in the panels?
So on infractions appeals, they will not move to panels. So in the Committee on Infraction space and in the independent space that we'll talk about, the group is so large, and it was intentionally done so that there could be a panel of individuals from that larger group that would hear any particular case. And that's how the Committee on Infractions operates, with a group of up to 24 on the Committee on Infractions at any one time. The panels are between 3 to 7 that would hear an actual case. And at the Committee on Infractions level, particularly in Division 1, that was important because of the volume of cases. So you wouldn't want, previously, the Committee on Infractions, again, prior to that 2012 Enforcement Working Group, and one of the recommendations that came out of that group, previously the Committee on Infractions operated the same way the Infractions Appeals Committee does, and heard every case, the 10-member Committee on Infractions, and that was important for consistency, etc. But over time, as the number of cases per year increased, that's a heavy lift for 10 volunteers, as we've talked about, in addition to their other work and responsibilities. So it was thought that it was important for the Committee on Infractions to expand to 24 and then hear cases as panels. Still speaking on behalf of the entire Committee on Infractions, but so that 10-member panel would not have to hear every case that came through the system, because honestly, at that point in time, it was becoming really untenable. Just the amount of work that it goes into hearing an infractions case, and the number of cases that were having to be heard. So the panel system has worked well for the Committee on Infractions, even though there has been an increase in appeals for the Division 1 Infractions Appeals Committee. I think the thought is that they think they are still able to hear the cases as one group, with these additional 2 committee members being added, so that can account for any conflict, recusal related issues, or availability issues. You would still have a good number, but they all plan as a starting point to hear every case.
And so obviously you talk about the appeals have increased in Division 1. You've increased the roster size of the Division 1 Infractions Appeals Committee. Timing wise, efficiency wise, how's that looking with all of these increases?
Yeah, so it's still a heavy lift, again, for volunteers who are doing this on top of their other obligations, but because they have, a real belief in fair play and accountability, and acting consistently with the rules that the NCA membership have adopted. So timing still, is something that, people definitely pay a lot of attention to, and we pay a lot of attention to. As I mentioned, there is now dedicated staff to the Infractions Appeals Committee, which is something that wasn't the case before. And I do think that there has been improvement in the amount of time that it takes to hear, from the hearing of an appellate case through when a decision is released from the Infractions Appeals Committee. And I think that's in part because of that now dedicated staff and those dedicated resources. There will still always be room for improvement, and I'm sure folks in the membership would want things to happen more quickly, as we really all do. But between requests that come, for extensions for different reasons during the processing of a case, and just, finding the time beyond the day or 2 that is dedicated, to hearing the oral argument and deliberating in person, that group still has work to do post the hearing of the oral argument, in order to come to a fully reasoned, decision that will be able to guide the membership, from that point forward. So they take the time they need, is the short answer, and we're always looking for ways to make the process as efficient as possible.
Absolutely. Okay, we're going to take a look at a couple additional groups here. We're going to take a look at the Independent Referral Committee and the Independent Resolution Panel. And so Another acronym, the IARP, the Independent Accountability Resolution Process, obviously was fully
Yeah.
implemented last August of 19. So if we could, let's go through some various components at a high level. And let's start with the Independent Accountability Oversight Committee. What is
Yeah.
that?
You got it. So I have said in other conversations related to this process that it's a little bit of alphabet soup, but we in the NCAA are used to our acronyms. So here's four new ones for you. As you noted, the Independent Accountability Resolution Process is that process that we have now mentioned a couple of times. That was one of the recommendations from the Commission on College Basketball. Within that process, the intended purpose, at least from the recommendation, was that there would be individuals that were untethered from NCAA member institutions making decisions about NCAA infractions matters. So that a different model than what we have operated under, which has been this peer review model, where you've got the athletic administrators, coaches, presidents, faculty athletic reps who are making decisions about whether or not violations of NCAA legislation have occurred and what penalties should assess. The Commission on College Basketball, probably in part fueled by a perception that perhaps in some cases, again, their perception, I don't necessarily agree with that perception. I think our peer review process handles the overwhelming majority of cases just appropriately and efficiently as any other process could. But I think the commission may have been fueled in part by this perception that member institutions weren't holding each other appropriately accountable in certain situations. That, I think, was the impetus for their recommendation, that you have these independent folks making the decisions. And that is really the crux of this new system, that the independent individuals, those disconnected from member schools, are making the ultimate decision. So that's kind of a high level overview of the process in total. And now we'll talk a little bit about the components. The Independent Accountability Oversight Committee, we'll call them the Oversight Committee for shorthand, is the body that sits atop of the independent structure. So they are the body that, in our parallel governance structure would be the highest committee, kind of setting the policy and the tone and the procedures for this independent structure. That committee is comprised of 5 individuals, 3 of whom are also as a result of one of the other Commission on College Basketball recommendations, which was that we add independent voices to our Board of Governors, which is the NCAA's highest committee. So 3 of the 5 independent Board of Governors members serve on this Independent Accountability Oversight Committee. They are Dennis McDonough, who is the chair, Vivek Murthy, and Grant Hill. The 3 of them, along with President Capilouto and President Trouth, who are the chair and vice chair of our Division I Board of Directors, serve as the 5-person oversight committee. They are not involved in any substantive issues on cases that will come through the structure, but they approve the policies and procedures that govern the structure, consistent with the legislation that ultimately governs the structure. They recommend the appointment of the 15 independent resolution panel members that we'll talk about. They appoint the individuals who will serve on the infractions appeals, alphabet soup. Infractions referral committee that we'll talk about in a minute. And then they also select the entities that could comprise the complex case unit on any case. So these are also independent entities. So the Oversight Committee has been very active since last summer, when the system became up and running and effective per the legislation. They made the appointments for the independent adjudicators. They appointed the Infractions Referral Committee, and they appointed the entities that would comprise the complex case unit. They've been a very active bunch. I have enjoyed working with them thoroughly, and they're all committed to making sure that this process is successful. One thing also to note is, we've talked about the peer review process quite a bit leading up to this, and I just mentioned the recommendation from the commission on these independent members to the Board of Governors. One interesting thing that I think gets lost as well is that our peer review process has had for over 2 decades now independent voices on the peer review side. It's not the dominant voice, but that perspective was recognized as being important in our current existing peer review infractions process for the last 2 decades. So we have always had public members, former judges, and folks that have really the similar makeup of now what will be the full independent resolution panel on the independent side. But that perspective has always, or at least for the last 20 years, have been a part of the peer review process. And it's been a good perspective to have. So, an athletic administrator or coach or president might have a different take on an issue that's being presented as an infractions matter than someone who is not as closely connected to college athletics. And that was a good balance. That was a good perspective to include. So that has been something that has been present on our committees on infractions for all 3 divisions and our infractions appeals committee on all 3 divisions for the last 20 years. So this is really an extension of that.
Excellent point to make, and yeah, it's a lot of aspects that most people don't realize, but it's what we've always kind of worked under. So let's dive into each of the 3 units a little more, and we'll start with the Infractions Referral Committee. So walk us through how a request for referral is made. What's that process like?
Okay, so as we just talked about, the Oversight Committee sits atop. The next group that really becomes really important for this structure is the Infractions Referral Committee. And I view them really as the gatekeeper for what comes into the independent structure. So their role is to receive any requests for a case to be referred into the independent accountability resolution process. A referral can be made in 3 ways. One is by the institution. An institution can request for its infractions matters to be referred into the independent structure. The second way is from the Vice President of Enforcement or his staff through him to make a request for a case to be referred. And the third way is for the Committee on Infractions, the chair of the Committee on Infractions, to make a request for a case to be referred into the independent structure. For the institution and the enforcement staff, they have a bigger window for when they can make a referral. They can make a referral from any time from the notice of inquiry, again, alphabet soup, that is issued by the enforcement staff to any institution. The notice of inquiry is pretty much the first document that lets an institution know that their case is they have an infractions matter that needs to be investigated. So that's kind of the triggering point. So once that institution receives the notice of inquiry, or when the enforcement staff issues that notice of inquiry, anytime from that point until all the way 15 days after the enforcement staff's reply to its notice of allegations is when an institution or the enforcement staff can make a request for a case to be referred. The Committee on Infractions doesn't get jurisdiction and otherwise know about a case really until a notice of allegations is issued. And that's the charging document that the enforcement staff issues in any particular case that says we've conducted our investigation and these are the violations that we think are are appropriately alleged. And the Committee on Infractions at that point, once that document is issued, then has jurisdiction of the case. And as a result, they can from that point through 15 days after the enforcement staff reply can determine that they want to make a request for referral. So everyone's end date is the same, but the beginning date and the window in advance is slightly different between the institution, the enforcement staff, and the Committee on Infractions.
Okay, so to that point, can one of those three entities move it forward to IARP without the other two being in agreement? Or I guess the other side of that is if it is moved forward by the Vice President of Enforcement or the Committee on Infractions, can an institution elect to go back to the peer review process once we're down that road?
Great question. So one of the things about this process is you could get in, but you can't get out. And there doesn't have to be agreement. So that's the other thing. So this is, yes, an alternative path. The requests can be made by any of those three. All of the parties to a case, including any involved individual, so that could be a coach or athletic administrator, that is known at the time that the request is made, since a request can be made in such a wide period, the parties to a case can change over time. But everyone who is known to the case at the point a request is made by any of those three can respond and state what their position is. We think yes, it should go. We think no, it shouldn't go. But ultimately, none of the three that can make a request or anyone who responds to the request that after it's been made ultimately can decide whether a case goes or stays. Who decides is that infractions referral committee that we started with in this portion of the discussion. So that committee is comprised of, it's appointed by the oversight committee, and then it's comprised of the chair and vice chair of the Division I Council. So that again is that connection to our Division I governance structure. And then there's one representative from the Committee on Infractions, one representative from the Infractions Appeals Committee, and they would be able to bring that perspective to the type of cases that, would be appropriately positioned in this new structure, right? And then it's chaired by one of the independent resolution panel members who has double duty. He serves on the IRP that we'll talk about, but he's also the chair of this infractions referral committee. So he's bringing that independent voice. Again, as we've talked about the oversight committee and the infractions referral committee, one of the things that I think is important to note is that there is an intersection on the oversight committee with the D1 board of directors and on the infractions referral committee with the Division I council. So there is a connectivity to our governance structure at those two levels that are setting policy and making decisions in this independent structure. The true crux of independence is that the people who are making the decisions are not connected to member institutions. So that's the one thing that I think is important to note with respect to the process.
And now there appears to be disclosure when cases are accepted into the IARP. Can you shed some light on how that came to be?
Yep, that's a great point, and another kind of distinguishing factor between the independent structure and our normal practices in the peer review process. Both structures, is important to note, are still governed by confidentiality that is articulated in Article 19 that governs the infractions process. But the Infractions Referral Committee is able to make that limited disclosure when a case moves from one process to the next. to the independent, from the peer review to the independent structure. It was thought that it was important for there to be transparency around that limited fact. We recently had an announcement related to a case that was accepted into the structure, so that there is, again, transparency around the fact that a case is in the structure and not the traditional peer review process. But there will be no further information related to that case, similar to how you wouldn't be commenting on a case in the peer review process until a decision is reached by the independent resolution panel related to violations and whatever penalties are appropriately assessed. So that was determined, that it was important to have that limited transparency related to when a case moves, and that procedure was ultimately put forward by the oversight committee and adopted and approved by the D1 board of directors.
Got it. Okay. Now the next branch underneath this is the complex case unit. So
Yep.
who comprises that unit?
So this was interesting because back in the last summer, when the system launched, there was a lot of attention being paid to this particular element of the complex case unit, and I think it was in part because there was a listing of names, so it almost felt like a committee, and that's not what it is. So the complex case unit is designed to sort of serve the role that enforcement would generally play in the peer review process. So in the peer review process, you have enforcement serving as the investigative entity, and they also have like a dual role because then they also present the case, their findings from their investigation to the Committee on Infractions. But they don't generally take an advocacy position, like you must find this school guilty as charged, Your Honor. We don't have a legal process, so it doesn't quite work that way. And, what the peer review model is predicated on is really this collaborative process, with the institution, a cooperative, and any involved individuals, a cooperative truth-seeking endeavor. These are the rules that the membership adopted. It appears that there is some conflict with those rules and the conduct that, is being alleged, and let's figure it out. I mean, that's really what the peer review model is predicated on. This independent structure and the complex case unit is slightly differently positioned because that role that the enforcement staff plays is clearly broken up between two separate entities. So we've got independent investigative firms, there are 3, and independent advocates, there are also 3. They're law firms, and the other firms are investigative by nature. And they will serve in tandem to really investigate. The investigative firm will take the lead on that. And then these law firms will then present the case to the independent resolution panel. So they'll work together as a team with support from the enforcement staff. And that is kind of outlined in the procedures as well, that there has to be that connectivity to enforcement because many of these cases will have started with them. So they will be there as support and a resource, but who is really directing the efforts are the independent investigator and the independent advocate that would be assigned to any particular case. So the oversight committee appointed those entities to be drawn from. Again, the 3 investigative firms and 3 law firms that serve as the advocates. On any particular case, the oversight committee would appoint the panel that we'll talk about in a minute from the 15 of the independent resolution panel members, just 5, but they also appoint the independent investigator and advocate from those that were already pre-approved, essentially, to serve on any particular case. They will take the recommendation from the enforcement staff of which entity should be selected, and then they would make their appointment based on that recommendation. So the complex case unit is the one that will basically conduct any investigation that's needed, and then they would be the entity that would be presenting the case to the independent resolution panel once a case is accepted into the process.
So boiled down even more, it's safe to say that the complex case unit, the individuals involved, are not affiliated with schools or conferences and are not affiliated with the national office.
You are exactly right. So these are multinational entities, in some instances related to the investigative firms and law firms that are disconnected and don't do work for the NCA as well, related to this now complex case unit. So similar to the independent adjudicators, these bodies were vetted and selected because they were not connected to institutions or the NCA.
Great. All right. And then we'll get to the last group here that you've referenced, the independent resolution panel. So can you tell us about the composition and background of the IRP?
Yes. So our independent resolution panel, this starts to get to the meat. The committee, the complex case unit got you a little bit there with the independence with respect to the investigative firms and advocacy firms. But then also now the real crux of the recommendation from the Commission on College Basketball was that you had those independent from colleges and universities making decisions about infractions related matters. And that's what we have. We have a group of 15 individuals that were recommended by and vetted by the oversight committee as part of its role, but ultimately approved by the D1 board. So they actually made the official appointment, so to speak, upon the recommendation from the oversight committee. So those 15 folks have a varied set of backgrounds. You've got arbitrators, you've got former judges, you've got one individual who was previously, an athletic director, but not currently. So you do have a little bit of that athletic world touch represented on the panel. You also have former student athletes, so they bring that perspective. You've got a former Olympian on the panel. So we've got we've got folks in private practice, but we've got, an impressive group of individuals, not dissimilar to what we have on the peer review side, with the folks with their incredible backgrounds who are, sitting in judgment of these cases on the peer review side as well. So we've got those 15, and like we mentioned before, for any particular case, a group of 5 of those 15 would be appointed by the oversight committee to hear a particular case that came through the process.
That and it's great to have that independent nature to this. The other side of that equation, though, as a lot of us know, NCAA rules, legislation is very complex and very in the weeds, and the more you're immersed in it, the kind of better you understand it. But since all of these independent individuals aren't very familiar with NCAA legislation, how are they educating themselves on how the NCAA is structured and worked and the rules to abide by?
Yeah, so our incredible staff that supports the Infractions Appeals Committee. Also, since there is no appeal, we haven't talked about this yet, but there's no appeal in this independent accountability resolution process. So any decision from the IRP ultimately is the final decision within our structure. That staff is also providing some support to the independent structure. And as a result, one of the things that the staff has put together is a pretty incredible, with the support of our academic and membership affairs staff, rules education comprehensive webinar series. So since August of last summer, the IRP have been engaged in pretty robust rules education that is done in part by our academic and membership affairs staff. High level overviews of various categories of the frequent flyers, so to speak, of rules related to any, particular infractions matter. So the ones that you would think of are the ones that have generally been the subject and the substance of any of the webinars that have been conducted so far. We get really great questions. These folks are incredibly smart and they're very engaged in the web to learn a little bit about the rules and the framework of the NCAA structure.
All right. Now, going way back to the beginning of this conversation, the Committee on Infractions, that process, the peer-to-peer has been in place for a while. We have this new group now in place if any of the three parties decide to go that route. What are the differences, if any, of roles of responsibilities between these panel members in comparison to the Committee on Infraction members?
Yeah, so great question. And the roles and responsibilities are essentially the same. They are the fact finders. They sit in judgment of whether or not violations of NCAA rules have occurred and what penalties should be assessed. The process and they're governed by the same rules. So this process doesn't have a whole new set of rules that they can, grab from. The rules are the same. It's the membership adopted rules that form the basis for any violations that would ultimately be alleged. And the penalties are the same. They don't have some new set of penalties that they can draw from on the IRP side. So they should be viewed very similarly to the Committee on Infractions. The process by which you get to one of those bodies is what is different and what will feel different, I think, to a member institution because it's just not what they would be accustomed to. Nobody wants to be accustomed to any of this because that means that there are some issues afoot, potential issues afoot. But that is really what the key distinction is. It's the process by which these matters will be resolved that is really the key difference. But the rules are the same. There are not new tools that the complex case unit are going to have, for example. All of that is really the same. It's who you're interfacing with that will be different for our member institution.
Okay. And along the same line of things that are legislated, there are deadlines when processing documents for the peer review process, but apparently there are no deadlines for the IRP. So can you discuss how deadlines for the IRP process will be established?
Excellent question. And that is a key distinction. We talked a little bit about the notice of allegations because that's a triggering point for when the Committee on Infractions can even potentially make a referral request. They can't do that until they get that notice of allegations. So this answer will be a little bit more involved because it is good for people to understand, that difference in terms of the timeline and the timing of the processing of a case. So backing up for a second, once the case is accepted into the independent structure, then the complex case unit has to determine that investigative entity and that independent advocate, along with support from the enforcement staff. If there is a notice of allegations, there might not be one if it's early enough before a notice of allegations was issued, right? So if there is no notice of allegations, they have to determine what investigation they need to conduct that hasn't already been conducted. And when they think a notice of allegations could be issued. If there is a notice of allegations, they still have the responsibility and the charge, so to speak, to review that notice of allegations and determine on its own whether additional investigation needs to be conducted, whether that notice of allegation needs to be amended or withdrawn entirely, and then issue a new one. the chief panel, once the panel of the independent resolution panel is identified, one of them will be selected as the chief panel member, similar to the chief hearing officer on the Committee on Infractions side. That chief panel member would then be responsible for establishing the case management plan, and that will dictate the timelines for the case. So the complex case unit may do that in concert with the parties. They may submit what they think is their proposed case management plan, and then any involved individuals in the institution submit theirs. But ultimately, the decision is going to be that of the chief panel member. So they will decide what time period would be prescribed for an additional any additional investigation, when a notice of allegations would need to be issued, when any responses to that notice of allegation to be issued, et cetera, presumably all the way up to scheduling a hearing. So there will be, for the parties, there will be a little greater transparency with respect to the timelines, because currently in a peer review process, you don't have it such that the investigative period is prescribed by anything. You know, the timelines are affiliated with the submission. So the notice of allegations, once that issues, that triggers the different timelines that would come thereafter, the responses from the parties, and then the enforcement staff's ultimate reply at the end of the process. So this case management order, schedule, plan, whatever word you want to use to describe it, that would be set by the chief panel member, would describe those time periods, and that is that's the document that will govern the timing of the case.
And just another circle back to efficiency as well there. So that's
yeah.
So we get through that whole process and we get towards quote unquote the end. You know, what types of determinations will the IRP make in an infractions case?
So it'll be the same that you see on the peer review side. The decisions that they make will be exactly the same and have the same impact. So they will govern the conduct of the membership going forward, just like Committee on Infractions decisions do. We will issue a public decision. It won't be a private decision. That will be available, you know, in LSDBI as a Committee on Infractions decisions also are, but it will also be available on the Independent Accountability Resolution .org website as well, where you would be able to find the decisions from the IARP. But the decisions will be the same. They'll be based on the same set of rules. The penalties available will be the same. Now, whether or not they read exactly the same, you know, might be slightly different, because the IRP will control kind of the mechanics of the decision, but the effect of the decision and what would be included in the decision would be the same.
And as you touched on earlier, with the clear distinction being no appeal. No appeal possible. Is that
no appeal?
Yeah. Okay.
That is it. The buck stops here. Once they make their decision, that's all they wrote.
All right. Now, in that process, do you foresee a difference in the hearings, in how the infractions hearings will be conducted in this new structure?
Yeah, I think they'll likely be fairly similar. But again, you know, there's already a slight nuance with the way the complex case unit will operate. You know, you'll have, you know, that firm that will be responsible for presenting the case. So that will be a little different than what the enforcement staff currently does. They certainly present the case, but now, but they also, you know, have just spent the time that they spent conducting the investigation. So they're really kind of putting forward, you know, their the presentation of their allegations and their investigative efforts that they undertook to come to the, you know, allegations that they're putting forward. This will be slightly different in that, you know, you will have this entity that's job is to advocate, as it says in their name. So that will be slightly different. But I imagine the setup will be pretty similar. But the IRP will have some say, obviously, on how the mechanics of the hearing will work. They will be certainly framed, and the parameters that are set forth in our Article 19 govern, the overall process. But the way that the hearing, kind of looks and feels will be a determination left to the independent resolution panel.
And would you say the same goes for the releasing of the announcements? I know you referenced LSDBI earlier, but will the IRP decisions be handled in the same manner?
So that's a great question, Cam, and that's something else. Again, the bylaws in Article 19 are the parameters, and certainly the procedures that have subsequently been adopted, provide a little bit more flesh on the bone, so to speak, for what is laid out in Article 19. But ultimately, the process by which a decision is communicated and how it's released and those sort of things will be decisions that the IRP would be able to have some input on.
Got it. So all of this that we've been talking about, as mentioned, this was created in August of 19, so we're not even a year in yet. But based on that, what feedback have you received internally, externally about the new process? Is it being well received? What are some of the things you're hearing about it? Understanding we haven't had a case go all the way through it yet. What are some thoughts you have there?
Interesting. So I haven't heard a lot directly from, kind of membership or anyone, kind of commenting on the process. Most of, what you're kind of hearing or what I've heard have been from, your colleagues in communication space, not necessarily connected with the NCA, but others, so there are lots of opinions about what it might be, but there's not a whole lot, to your point, because we haven't had that first decision yet. So I think that, with anything new, we're still trying to figure out, some of the mechanics related to how all of this will work, and these structures are how they intersect with one another. But ultimately, I think things have gone very, very well, and it's a large credit to folks within our membership who were part of the infractions enforcement working group that was one of the bodies constituted in response to the Commission on College Basketball. And once those recommendations came out, we kind of organized ourselves as an association with various membership groups that were looking at different recommendations and how they could be implemented within our structure. So the majority of what this process is was really through that work of, great folks within the membership who spent a lot of time, trying to see around the corners of how A would work with B and connect to C, et cetera, if we were going to adopt this independent structure, which we ultimately have. So a lot remains to be seen, but I think the process is working well. And I think it's in large part because of some of that good thought that was put out in advance by folks on the, from the membership, representing the membership's interests in how this kind of system would work.
Great cap to this conversation. Naima Stevenson Starks, thank you for taking the time. We appreciate this, and I'm sure the audience feels the very same way. So thank you again.
Thank you, Cam.